Welcome, everyone. Thanks for joining us. This is a spacious room, but I know unfortunately it doesn't have a window to the beautiful day that we're having. So thank you all for coming inside to join the Binger Center for New Americans. This is the first year that we are doing an Alumni Week CLE. My name is Sarah Brennes. I'm the Executive Director of the Binger Center for New Americans. For those of you who aren't familiar with us, hopefully you grabbed one of our annual reports upstairs. But we're really a unique center within the university, within the law school, and really kind of a national model. We're one of the only law schools in the entire country that has 4 immigration clinics and are really deeply embedded in our community. We were founded and work in close partnership with our nonprofit partners and law firms who do pro bono work in immigration. And we provide a variety of opportunities for students to not only explore immigration law, but to also practice and shape immigration law and policy before they're even licensed attorneys. So as I mentioned, we house 4 immigration clinics serving recent arrivals and long-term immigrants with brief services and advice. Our students provide full representation to asylum seekers, immigrants who are in detention, and represent them before the U.S. Citizenship and Immigration Service and the Immigration Court. And students also work with immigrants on their appeals, including cases before our circuit courts and the U.S. Supreme Court. The center also supports law students in experiential learning placements with a variety of nonprofits, private attorneys, and firms, and partner with our student-led organizations, including the Asylum Law Project and the student affiliate of the American Immigration Lawyers Association, to provide learning and volunteer opportunities to students, a broad range of students from the time they're in their first year through their 3rd year. And we're also committed to providing education to immigrants, to allies, and to the legal community through education outreach. Often in collaboration with our community partners and with colleagues throughout the university system. We have a fall immigration forum that focuses on thematic topics and explores the intersection of immigration law with other disciplines and advocacy movements. And in the spring, we co-host the Upper Midwest Immigration Conference, which is more of a technical legal training for lawyers, and do that in partnership with the American Immigration Lawyers Association and the Advocates for Human Rights. The center was founded by a number of University of Minnesota law alumni who were providing legal services to low-income immigrants as solo practitioners and in nonprofits or through pro bono work with firms. And over the past decade, the University of Minnesota law alumni and a growing number of actual alumni that have gone through and worked with the Binger Center have been an integral part of our work. Alumni serve as full-time and adjunct faculty and fellows in our legal clinics. They act as field placement supervisors for students who are doing experiential placements. We actually have 3 U of M alumni who graduated from the 90s that are now, actually 4 that are executive directors of our local nonprofits that are serving the immigrant community, and have had over 10 recent graduates who've received support from the Binger Center and have launched careers joining our local nonprofits to provide legal services to low-income immigrants. And over the last decade, about a quarter of the students that have gone through Binger Center clinics enter in practice in immigration law after graduation. So today we're pleased to have some future alumni that are going to share with you today some of the work that they've done in 3 of our immigration clinics this past year. Faculty and fellows from the 3 immigration clinics will introduce their clinics and the work they do, and then hand it over to the students. We'll have an opportunity to present, and then we'll open it up to some questions at the end. So without further ado, I'll hand it over to Mackenzie Heinrichs, who is a fellow with our Immigration Human Rights Clinic.
Hi all, thank you so much for joining us this lovely afternoon. Great weather outside. So I'm Mackenzie Heinrichs. I'm a fellow and visiting assistant professor of clinical law, and this is actually the 3rd year of my fellowship and my final year. And I also was a graduate of the University of Minnesota Law School in 2018 and a former clinic student and student director in the Detainee Rights Clinic. So guess I'm like double Binger Center here. And that experience has made a huge difference in my life. And not to like toot my own horn, but I'm able to start a new job this July as a associate professor of law and clinical director of an immigration clinic at the University of Utah because of my experience in the clinics and all of the work that I've gotten to do with students and supervisors and other professors. So the Immigration Human Rights Clinic, we're actually the oldest immigration clinic at the University of Minnesota. We kind of have a classic model of doing affirmative asylum applications was the idea. And I don't know if there's other immigration attorneys here, but back when you could do an affirmative asylum application in one school calendar year, excuse me, which is no longer possible for most, right? Most people wait sometimes 2, 3, 10 years for an asylum interview. So we've had to broaden our horizons a little bit. We do defensive asylum in removal proceedings. We've done U visas, T visas, generally humanitarian kind of protections for immigrants. So we're looking forward to continuing that work, and thank you again, and I'll pass it on to Sam.
Hello, everyone. My name is Sam Miller, and I'm a second-year law student here at the University of Minnesota Law School. And I am currently one of the students in the Immigration Human Rights Clinic. And next year, I will be one of the student directors. And I know we're going to get into a little bit of the specifics, but just to give you a little bit of my background, I came to law school from a 6-year career as a first-grade teacher just in the North Metro area here around Minneapolis. And one of the most challenging parts about starting law school and being a 1L student was just like coming back and then being a student, right? And so I got to here and I was in contract, civil procedure, constitutional law. And I showed up in a classroom like this every day and I was sitting there and I was listening to my professor, taking notes, and then I'd go home, I'd read, and I'd come back and I'd do the same thing again the next day. That was really different than what I was doing as a first grade teacher, where every day I was teaching 6- and 7-year-olds how to read. I was teaching them how to make friends, and it felt like I was making a meaningful difference in their life. And so then I knew like part of going to law school was going to be sitting in those doctrinal classes. But why I bring that up is because then when I got to the Immigration Human Rights Clinic, I started to get a better it was just an appreciation of this is what I'm doing here in law school, right? I've had a chance to work with real people, making a meaningful difference in their lives. And it's been just the best part of law school so far. And so I'm just really thankful to be part of this clinic and then to continue that work next year.
So Sam and I both have worked on an asylum case this year, and obviously I've worked on several different asylum cases. And if you've been following the news or the law, right, there's been some massive changes to asylum policy throughout the nation. And we want to talk about changes that have affected asylum seekers, recent asylum seekers who've come to Minnesota that we've seen in our work. So I'm just going to highlight 3 policy changes before I pass it over to Sam to kind of talk about how it's actually affected, his life as a student attorney and working with clients. So the 3 main policies I'm going to highlight are CBP One app, or now called CBP Home, the expansion of expedited removal, and the rescission or kind of pause of a lot of forms of parole. So the CBP One app, right, for people who aren't familiar, was basically the main way for people at the southern border who came to seek asylum in order to actually apply for asylum, right? It was a mobile phone application started in 2020 that folks would essentially kind of put their name in the hat, wait to get an appointment, and supposed to facilitate more order at the border, right? There had been previous policies like metering where people were putting their name in a little book and having to wait for their number to come up. And this was seen as like a Biden-era policy to sort of fix that problem. Of course, it wasn't without its own issues, right? People were waiting, I think like the average became like 9 months for an appointment. So people are in Mexico waiting 9 months for an asylum appointment at the southern border. But ultimately, it was the main way people were actually able to apply for asylum. So on January 20th, 2025, Trump administration, right, new administration happened, they immediately shut down the CBP One app and they canceled all existing appointments. So there were, I think they said it's like 30,000 appointments had been canceled. It was an insane amount. And people had, again, been waiting for months. And clients we've worked with in the clinic who are recent asylum seekers have come through that CBP One app. And another big feature of the CBP One app is it allowed people to come into the US, right, legally with permission on something called parole. So it facilitated, right, the entry of asylum seekers into the US. Most people were put into removal proceedings. They were, in the system, they were registered. These were, I would say, right, legal immigrants, at least according to the general definition, but right, are now being targeted by the Trump administration. And this was also used for the CHNV parole program, Cuban, Haitian, Nicaraguan, Venezuelan parole, which was its own separate program. So that was also facilitated through the CBP1 app. So the termination of that application, termination's maybe not quite the right word, it was rebranded to something called CBP Home app. So the new administration has utilized essentially the infrastructure of the app that's on people's phones, and it does some of the same things, like you can schedule a customs inspection, but it also has a self-deport feature. So now it's being used to facilitate people's self-deportations, people who came in right on CBP1 parole or that CHNV parole. And that would also include like Afghan parolees, Ukrainian parolees who utilize the southern border kind of CBP1 app. They can choose to self-deport right through this app. So instead of being used to schedule asylum applications, now it's being used to facilitate, that 1 million deportation number. And so for clients who came in on parole, all of their information and email is in this database. And so then another thing that happened with the new administration is rescission of CBP1 app parole and the attempted rescission of that CHNV parole. So you may have seen in the news that some US citizens, even some immigration attorneys, received notices that they needed to deport immediately because they were here without lawful permission. Their benefits would be terminated. They'd be subject to criminal penalties, right? And it's because the current DHS had just used all the information from the CBP1 app in order to try to remove people or force people to kind of remove themselves through fear. So a lot of asylum seekers in Minnesota, recent arrivals who've come within the last couple of years, received that really terrifying kind of self-deport notice, and they lost their parole, which parole has a lot of benefits, like a work permit, lawful permission to be in the US. So it's a huge blow to recent arrivals in our state. The other kind of scary feature that came along with this kind of getting rid of the CBP1 app and the sort of pausing or getting rid of a lot of parole was the expansion of something called expedited removal. And it's essentially a form of removal that includes little to no due process. So under the Biden administration, it was typically applied to people who were within 100 miles of the border, who had been in the US for, I think it's 14 days or less. And the Trump administration has expanded expedited removal to everywhere in the United States for anybody who's been in the US for less than 2 years. But you have to prove, right, that you've been in the US for over 2 years. So even if you are undocumented and been in the US for maybe 10 years, if there's no way to prove it, it's possible that you could be subject to this expedited removal. And the memorandum that implemented that expedited removal explicitly said that DHS should consider people who were on parole. So this put a huge burden, again, on recent arrivals, recent asylum seekers coming to the US. They had to make sure their asylum application was filed as soon as possible to give them some protection. And DHS was kind of saying, if you did not file your asylum application quickly, you could be sort of prioritized for removal. So this is just kind of to show that these kind of crackdowns on the southern border on asylum affects, right, not just people at the border, but affect all people right throughout our country in Minnesota seeking asylum, and have had really negative kind of consequences for our clients. So I'm going to let Sam talk about the kind of client and student experience.
So Mackenzie kind of talked about like from the kind of macro point of view, and then just to bring it in more micro, just with our client in particular, she mentioned some of the messages, but I just want to read some of them verbatim for what our client received from the United States government. And so one of them said, quote, "If you do not deport the United States immediately, you'll be subject to potential law enforcement that will result in your removal from the United States unless you have otherwise obtained a lawful basis to remain here." And so they kind of they leave that second part till the end because they really intentionally want to scare like people like our client into that, as Mackenzie was alluding to before, self-deporting themselves regardless of what status they have acquired or what status they're on their way toward acquiring. Because at this point, when people were receiving these notices, our client in particular, she was no longer on parole. We had filed her asylum application, so she moved into the next step of the process. But the government didn't really care for those nuances, and they want to make sure that they can get as many people as possible to self-deport. And so, as you can imagine, that really creates just a culture of fear and instability. And in the clinic, we were able to see that firsthand because oftentimes our client would text us that she has questions about what she sees in the news. She sees what the government is doing in Minnesota and elsewhere, and she wants to know how that's going to affect her. And one of the hardest parts about being in this program, as opposed to like what I did as a first grade teacher, because I was used to having the answers for my first grade students, I could protect them, I could keep them safe in lots of different ways. But then coming here into this program, our client is coming to us and she is scared and she doesn't know what's going to happen next. And the problem is, neither do we. And we can give her the best advice that we can, but ultimately we don't know what's going to happen next. And so as responsible attorneys and student attorneys, we're going to tell her that too. We'll tell her as well that we're going to be there with her every step of the way, but we just don't know what all those steps are going to be yet. And so just thinking about how the process changed, just even from the first semester when I started, which was still during the Biden administration, to then January when the spring semester started. Everything that I was working on in the immigration with the support of Mackenzie and Steve and my student and Cece and Harshita, who are other students that are on my team as well. It felt overwhelming just coming into the immigration system at first to learn the system, but it also felt like there was a system. I had people that were there that had experience with the system, like Mackenzie and Steve, that were able to guide me and then the students that I was working with through the steps that we were going through. But then as the Trump administration came in, we often found ourselves asking, what is the system anymore? Because as much as they can, they're pulling, they're making as many changes as they can, as fast as they can on purpose to try and throw not only the asylum seekers off balance, but then the attorneys that they're working with as well. I know I saw even just today in, I think it was Texas, there was an attorney that's not even an immigration attorney, but he was somebody that talked with somebody that was seeking asylum. And then there were unidentified law enforcement officials came to his house. And he noticed when they got there, his VPN turned off, and then he realized that his Wi-Fi had turned off. And then he went to the door and he was talking to these officials, and they didn't identify themselves. They told him they didn't have to tell him all of that. And then he asked them explicitly what it was they wanted to, who they were working for. They didn't want to identify themselves. And then they left and he went back and he noticed that his Wi-Fi had turned back on. He wanted to use his Ring camera to be able to identify who they were and go to somebody else, but his Ring camera wasn't working because the Wi-Fi was shut off. And so there are just so many different examples like that nationally, but then locally too in our clinic where it is changing so fast and it just makes it that much harder to work within the system. And that kind of brings me to this weird paradox. And so it felt like when we first started, we were working really fast, kind of day and night to try and file this asylum application so we can move to the next step and our client wouldn't be subjected to those messages that I read you before. And so there were a lot of deadlines that we had to meet, and those deadlines are obviously there intentionally. And if you don't meet them, some can be fatal to your asylum application. And then once we did meet those, it's like the reverse. The immigration system just slows down. Like I know Mackenzie said before that some of these cases that we work on in our clinic can take 1, 2, 5, 10 years. And it's really felt like that lately. We have our client who wants to get to work. She wants to start a life in the United States. But because of how long this process takes, she feels like she's not able to do all of that for good reason, obviously. And then just thinking about how we anticipate these different policies from the Trump administration to continue to affect the work that we do here in Minnesota. We're already seeing a chilling effect, obviously, on the number of asylum seekers that are able to enter the United States. And this isn't something that we really anticipate changing probably before Trump is no longer president. And it has been really depressing oftentimes, but I don't know, from just like being in the clinic and the work that we're able to do, it feels like we're able to counter that depression just a little bit. And even beyond just our clinic, looking at Ruby Red, Iowa, and we have people yelling at Chuck Grassley, just getting red in the face about what's happening to Kilmar Abrego Garcia. People are starting to notice and the message is starting to get through. It feels like the tide might finally be shifting in the immigration debate, and it has really been meaningful to get to be part of that here as the clinic. And so people, they are upset about these unidentified masked men scooping people off the street. And so it shouldn't, I know we all agree on this, have taken any of this for the tide to start changing, but it's here. And I believe that eventually we will have a chance to change immigration for the better, and we just need to take it.
Thank you.
Hi, good afternoon, everyone. My name is Nadia Anguiano, and I direct the Federal Immigration Litigation Clinic, which I teach with another fellow in our program, Seiko Shastri. And piggybacking off of what Sarah said, the impact of the Binger Center is right here in this room. I'm a proud alum of the clinic that I now direct, so is Seiko, and I see a lot of faces in the room who've walked through our program. The Federal Immigration Litigation Clinic, for those of you who may not be familiar, is one of the 4 clinics of the Binger Center, the one that's focused primarily on appellate litigation in the federal courts. And we have cases in mainly U.S. Courts of Appeals, but sometimes up to the Supreme Court, including in the case that these wonderful 3L student directors are going to talk about. And we don't have a substantive focus unlike Mackenzie and Steve's clinic that's mostly focused on asylum seekers. We are an equal opportunity defense firm where whether you have contact with the criminal legal system or you're an asylum seeker or just an individual who's been here for a really long time seeking to stay with their family, give us a call. And I'll turn it over now to these wonderful folks, Alex Lloyd, Sean Aslin, and Chloe Chambers, who I'm really sad about. They're going to be graduating within the next 3 years. I'm trying to figure out how to keep them. But they were one of the teams that had one of the cases at the U.S. Supreme Court that Philk had last academic year.
Hello, I'm Alex Lloyd, one of the 3L student directors with Philk.
And I'm Sean Aslin, one of the 3L student directors.
And I'm Chloe Chambers, one of the other 3L student directors. We're just missing Hans Frank Holzner, who is on paternity leave.
So we know people here may have a variety of experiences with immigration law, but I imagine almost everyone has probably seen a lot of the news about removals to El Salvador, particularly of Venezuelans based on the Alien Enemies Act. So we're going to be focusing on that part of Trump's recent attack on non-citizens and talking a little bit about how those have been based largely on people's tattoos, which relates to a Philk project from last year, a U.S. Supreme Court amicus brief in Department of State v. Munoz. So we're going to talk about the Alien Enemies Act, our casework, and then also discuss a little bit about how our client stories and narratives can be a part of building a strong legal case, as well as communicating to the public about the need to protect immigrants.
So has been extensively reported, the administration has been targeting non-citizens, many without criminal records, based solely on their having tattoos. This started earlier this year when the administration was using Guantanamo Bay as an immigration detention site, and it has continued with the removal of non-citizens to El Salvador. The administration claims that these tattoos are indicia of gang membership to groups such as Tren de Aragua and MS-13. And the administration has designated these groups as terrorist organizations. And based on that, they've invoked the little used Alien Enemies Act of 1798 to justify sending these alleged members of these groups to El Salvador. And the glaring problem with these actions is that there's no due process. We have no idea if these allegations are accurate. The accused non-citizens have no opportunity to contest the designation. And the only explanation is apparently their tattoos, many of which are commonplace or widely adopted by other members of the public.
Yeah, so a recent ACLU court filing challenging these removals identified these 2 guides, which the government is using to process detained Venezuelan men as members of Tren de Aragua. So if you get 8 points on this checklist, they'll classify you as an alien enemy and summarily deport, which the Trump administration has used to send people to the Salvadoran prison, Secot. So you can see that having a tattoo is worth 4 points, and wearing Chicago Bulls attire is also worth 4 points. So if you are Venezuelan, a man, have a tattoo of some kind and are wearing Chicago Bulls attire, you're a gang member, according to the administration. And as we'll discuss later, that is not a reliable way to determine if someone is in a gang. I point out that the clock tattoo there in the official guide is on a British man who has never been to the United States.
So like Sean mentioned, this started a little bit back in February with the detentions in Guantanamo Bay. And even then it became pretty clear that tattoos were playing an outsized, if not exclusive role in determining who was a gang member. And then that has really escalated recently with detentions in El Salvador. So these are just a few of tattoos of individuals that have been in the news for being sent to El Salvador. Neri Jose Alvarado Borges had this ribbon tattoo for his brother with autism. Jersey Reyes Barrios has a soccer ball tattoo that is similar to the logo of the Real Madrid soccer team. He also is a professional soccer player. That was used to accuse him of gang membership. And then these crown tattoos belonging to Andre Jose Hernandez Romero relate to his background in Venezuela, where his village had an elaborate Three Kings Day celebration every year. But again, crowns are on the Tren de Aragua tattoo guide, according to the Department of Homeland Security. And so he has been sent to El Salvador as well.
So this story is also an example of how the public and the media interact with legal proceedings. When attorneys were writing, we generally want to focus on how to best present our arguments to other attorneys, judges. But the public just doesn't generally understand the complex minutia of immigration law or even basic concepts like due process. So the difference in framing is prevalent depending on what source you're looking at. So the legal focused headlines are from more legal focused publications. They talk about the Alien Enemies Act being invoked and what does that mean legally. Whereas and you know, that's not a bad thing to focus on that. We're attorneys, they're attorney focused publications. But you can see from the headlines focused to the general public that they're actually focusing on the people affected by this invocation and what it's doing to their everyday lives. So one of my biggest personal failings is I spend too much time on Twitter. And what I've been seeing is when people pull up these court filings, a lot of times they're really just reading the introduction and they're going to latch on to the thing that really tugs their heartstrings. They want to know what's happening to this person and what injustice have they suffered. They're not going to understand the legal framing. So it's our job as advocates to clearly lay out the narrative to support our clients, to the media, to the general public, so the readers don't have to do as much work trying to figure out why this should matter.
So as Chloe has touched on, there's sort of this tension between, the doctrine, the Alien Enemies Act, what can the executive branch do? And then on the other side, the sort of simple truth that people are being disappeared to El Salvador based on their tattoos. And that tension and relationship between, the legal and the narrative was also part of a FILC project from last year. So we worked on a Supreme Court amicus brief on behalf of a non-citizen, Mr. Asensio Cordero, who'd been accused of gang membership also because of his tattoos. And as an amicus party, we were writing a friend of the court brief. So we were able to lean into some of these other narrative arguments, bring in additional scholarship beyond just the pure legal arguments and try to merge these two different kind of thematic issues of the doctrine and the story at the center of it.
So in our amicus brief, we were supporting Ms. Munoz, who had successfully petitioned for her husband, Luis Asensio Cordero, to become a lawful permanent resident in the United States. However, he was denied a visa after his consular interview in El Salvador, and the government refused to give the reason why they had denied his visa. 3 years after the denial, Ms. Munoz and Mr. Asensio Cordero learned that the reason he was denied was because the consular officer believed that his tattoos signified gang membership. Generally, the decisions of consular officers are non-reviewable unless they interfere with a liberty interest. So Ms. Munoz sued, alleging that the 3-year delay infringed on her fundamental right to marriage, which she argued includes the right to reside with one's spouse. So the amicus brief was written on behalf of 8 legal scholars and practitioners. And we wrote about the misuse of culturally significant tattoos to impute criminality, a practice that law enforcement disproportionately uses against people of color. So the brief laid out in great detail the cultural significance of Mr. Asensio Cordero's, 2 of his tattoos that it was believed the consular officer took issue with. They're both on the far right of the screen here. The top tattoo is La Virgen de Guadalupe, and then the one on the bottom is the smile now or laugh now, cry later tattoo. And so La Virgen de Guadalupe is a symbol of Mexican American identity, and its cultural salience is such that it has been adopted by people from other Central American countries as well. The laugh now, cry later tattoo has also been widely adopted by members of the general public, including people like professional athletes and singers like Harry Styles. And so unfortunately, the Supreme Court ruled against Ms. Munoz. So consular denials like this will continue to occur with no process or review.
So these are some news articles I pulled up from after that ruling, and you can see that the legal focused articles are talking about what this means for consular processing, whereas the articles that are focused on what's happening to the actual people within the litigation are talking about how this affects people's right to marriage, because one of the big problems is the majority did not cite Obergefell, which is the main case about the right to marriage. So you can see again that the distinction between how attorneys focus on something versus the general public, who are more focused on how is this going to affect people's lives going forward.
So when we're thinking about the connection between these narratives, between the current moment of Venezuelan detention in El Salvador, and then Philk's work on the Munoz amicus brief, I think something we're really seeing is that the government is leaning on these elaborate legal theories about why they can deny people certain relief or remove them from the country based on their tattoos and then not have to have any reviewability or accountability for that decision. And then there's also the contrast of, just the truth of the matter, that these are just based on tattoos and tattoos belonging to people of color. And that is wrong and racist and a violation of a variety of due process principles. And so in working on the Munoz amicus brief, we were able to get beyond that pure legal argument to bring in other types of scholarship and really highlight, that core truth at the center of the case. And although we did lose, our brief was cited by the dissent, and I think was able to complement the legal arguments in a really meaningful way. And in responding to the current moment, I think we're again seeing the value of telling people stories, of highlighting the injustices at the center of their cases in order to develop strong legal arguments and fight for their legal rights, but also, communicate to the public why this matters, what's happening, and to fight against the injustice, in the court of public opinion as well as the court of law. And just to conclude, I think we'll all share just a little bit about, our final reflections on what kind of reflecting on this case in the current moment has been for us. So Chloe, if you want.
So I would say my main takeaway is that attorneys maybe will read your 60-page brief if it's not the case they're working on, but the public certainly is not going to. So as advocates, it's our job to put what is the injustice? Why should the public care about this? What's wrong? What did the government do wrong right up front in the introduction. Make your legal arguments later. The judge, opposing counsel, they're going to read them. But make sure in those first few pages to tell the public what happened, what is the injustice.
And I think along with that too, I've thought, and we've talked about, using the simplicity of your client's story too, to cut through some of the legal complexity and use that to build a strong case. And, you've got to understand the jurisdiction and the complex legal issues, but also when you have a core truth that an injustice is happening and people are being persecuted because of the tattoos that they have, that can also shape and strengthen the legal arguments about what due process is supposed to look like in this country.
And I agree with everything that Chloe and Alex said, and I would just add that even though we're a litigation clinic, working on the amicus brief and seeing the events of the past few months has really driven home that litigation, even though it's a powerful tool, is not the only tool that can be used to fight for immigrants. And like they said, really putting forward the simple truth of the injustice to the public is a really powerful way to sway public opinion in favor of immigrant rights. So, thank you.
I'm not gonna use a mic. I'm usually loud enough that I don't have to, but can everyone hear me okay? Okay, so my name is Linus Chan, and I direct the Detainee Rights Clinic. And in that clinic, we represent people who are either being held by Immigration and Customs Enforcement or under threat of being held in detention by Immigration and Customs Enforcement. Obviously, this last change in the administration has provided quite a few challenges to that work. And I'm very grateful that Nate is able to be here to help talk about his work with me. My two other student directors happen to be preparing a witness on a derivative citizenship case that we are going to have our merits hearing for next week. So that's why they're not able to be here. But I think what we're gonna do is just go ahead and have Nate be able to present. And then if I feel the need to kind of chime in, I might chime in a little bit. But we hope to be able to give you a little bit of a sense about what we've been doing and how we've been trying to figure out our role and our what we could potentially do in the next, well, I would say 4 years, but I think our time window is more like a week and a half.
1 second, so there's some technology things we're figuring out here. Turn it to you.
Well, while this is happening, does anyone have questions? I'll take the teacher's prerogative. Anyone have questions about immigration detention?
What's changed in the last 2 weeks?
2 weeks. Good. Some things have changed. Many more students are fighting for their student visas. They are in danger of having, they've been told that their student visas have been revoked and they've been sent letters similar to what was talked about Mackenzie. Your visa has been revoked, leave. What has changed in the last 2 weeks is, of course, unfortunately, we also know that some of those students are being detained and being forced into removal proceedings under very, very scary situations where undercover ICE officers in one instance went to a hospital, told their hospital co-workers to lie and to trap the person coming in. This is a student. Another situation where officers followed a student from class in order to surround them with 4 different vehicles and arrest them in front of their house, in front of their parents who had just come to visit to watch his siblings graduate from college. And what we're seeing is that I'm involved in one of the cases. We filed a habeas case, and we are arguing that the government is doing this in part because of protected speech. and in part because they also want to force these students that they've revoked their visas to leave the country. So that's one aspect of detention that's changed. Another aspect, just today, another, I think, 145 detainees were sent to Guantanamo. So Guantanamo, you know, that was the first order before we heard of CCOT, right? Now Guantanamo is making it back in. There are people being sent to Guantanamo. And then, of course, just last week, the group of people that the government has charged with being alien enemies, the Supreme Court has stepped in and prevented their removal, rendition. We hesitate to use the word deportation because it is not deportation under the statute. It seems to be quite a different creature or animal than it is. And I'm sure I'm missing lots of other things, but that's some other things in the last 2 weeks. Are we ready?
Yep.
Okay.
Right. I'll try it. Is this on? No, it's beautiful. I'll try with this one.
Press play.
Hello? Okay, great. Okay. Hi, everybody. My name is Nate Bander. I am a 3L in the Detainee Rights Clinic. I think I can do this without this. Well, I'm not a mic guy. So we're going to talk primarily today about pardons as an avenue for immigration relief. But I want to frame that conversation by what we are seeing in the Detainee Rights Clinic and our work, and Linus alluded to this a little bit. And the way I want to start that is by talking about this flawed idea of the good immigrant versus the bad immigrant. I think that many of us in this room would agree that that concept is problematic. For one, it doesn't recognize that the US has duties under international law, whether someone is good or bad, to serve as a safe harbor for non-citizens, fleeing whatever hardship it is around the world that they are. But this administration in the last 3 months is showing us another reason why that dichotomy is so troubling. And of course, you know, there's those who say that this deportation system that we have that's punitive, draconian, some would say. Some people say, oh, it's fine if you're the good immigrant. Well, I think this administration is showing us how that is also a fiction. So in our work with the Detainee Rights Clinic, in visiting ICE detention centers, and as Linus alluded to, more recently with folks who have had their visas terminated, we've seen that being the good immigrant doesn't really save anyone anymore, even if that dichotomy was true. The people who are being affected, as we all know, are the best of the immigrant community, people who are engineers, physics PhDs, undergraduate students on the honor roll. And those people don't have any immigration violations, very little criminal history. They often have strong ties to their university or to their community, but they're nevertheless being treated as presumptively suspect in violation of due process. These folks that I have seen in just doing the project that we've done in the last week or so are people who have minor traffic violations. They had a shoplifting case dismissed. Sometimes they have law enforcement contact that doesn't even result in a charge, and yet still there's detention, they're losing their status, being kicked out of universities, and being put in removal proceedings. And so one thing that we are inspired in doing is potentially using the idea of state pardons as a way to help these folks out, especially those with like really basic minor criminal histories. This came to us through our interactions with the Southeast Asian immigrant communities here in the Twin Cities. Those who have practiced immigration for a while may remember the Minnesota 8, who were all at risk or deported during the first Trump administration in about 2017, I believe.
17, 18.
Yeah. And that is sort of, I think, when you became involved in that community, And that community in Minnesota primarily made up of folks who have Lao, Hmong, Vietnamese, Thai, Cambodian heritage. They came to the United States fleeing the Khmer Rouge, fleeing the aftermath of the Vietnam War. And like many immigrant communities, they didn't get off on the right foot all the time because there were not the resources available for them. Because of that, some of them joined what would really be called cliques. Gangs is probably not even the right word here, and engaged in like low-level criminality. And so for some folks who never sought citizenship or never got it, those issues from when they were 19 years old in 1995 or whatever are still at play here because they are now once again at risk of deportation or removal or other adverse immigration consequences 30 plus years after the event. And so I wanted to talk about an avenue of relief for them, which in the last 3 years has sort of become an option because of some changes to the way that Minnesota does pardons. And so a quick little bit of history on that. Minnesota hadn't pardoned anyone for like 25 years. And then partially because there was a unanimity requirement for the Board of Pardons. And all three of the members, that they're made up of the governor, the Chief Justice of the Minnesota Supreme Court, and Minnesota's Attorney General, they all had to vote yes on the pardon. Then, a couple of years ago, that law changed. Now it just has to be 2 out of the 3. And so there is an opportunity here for a group of progressive, the 3 that currently make up the Board of Pardons and their staffs are obviously like relatively progressive. They have shown a willingness to potentially help immigrants get relief in this way through pardon. So let's talk a little bit about that. This is important because in the Immigration and Naturalization Act, there is a clause called the Pardon Waiver Clause that basically makes non-citizens or aliens deport or not deportable if they receive a full and conditional pardon by the president or a governor. That is why we have this possibility. The words "by the governor," importantly, don't have to literally be by the governor. There was a case from Connecticut that said that the Board of Pardons or some other clemency-related board acting on behalf of the governor is enough to get a pardon. As I mentioned earlier, Minnesota has a 3-person Board of Pardons. But I do want to note that like expungements, so if you just get your criminal record expunged, or if you have a sentence commutation, that does not provide immigration relief. But a straight up full pardon from the Board of Pardons in Minnesota would provide that. So from a sort of state law level, a pardon sets aside your conviction. You can see kind of in the second line there, a person shall never have to require to disclose their conviction, and it's erased for the purposes of immigration. This helps in certain examples, people who have a CIMT, a crime involving moral turpitude, if they have multiple CIMTs, it even helps in aggravated felonies. And then this is pretty rare, but it would be if they had a high-speed flight from like the southern border or a different immigration checkpoint. Unfortunately, there are a lot of issues that come up, criminal histories that actually can't be helped by pardons. The biggest one is drug offenses. That is just under the Immigration and Naturalization Act. Drug offenses, even if they're pardoned, it's not going to provide immigration relief for a non-citizen. Firearm offenses are the same. That is not necessarily any offense committed by a firearm, and that's a important distinction. So like possession of a firearm, that would not, there would be no immigration relief for that. But a armed robbery that was committed with a firearm, or even murder that was committed with a firearm, could theoretically be pardoned, and it would be good enough for immigration purposes, because those don't have to be committed with a gun. You know, you could use a different weapon or something. Domestic violence crimes, child abuse are also not, there's no grounds for relief there. And then, as we've seen, folks are getting in trouble or getting into issues right now based on crimes that weren't even really crimes, that they were dismissed. The charges were dismissed. Maybe there was not even an arrest. Pardon's not going to help it. But there's still a big group of offenses in which a pardon would be helpful for. I do want to mention that if like other immigration areas like good moral character, you can't, just because you get your conviction pardoned does not mean that for purposes of showing good moral character, which comes up a lot in like naturalization, for example, that's not going to help you. This is just for deportation or removal. Okay, so to be eligible for a pardon in Minnesota, this individual has to be convicted from by a Minnesota state court. So Wisconsin pardon or Wisconsin convictions will not work, and nor will anything federal. You cannot have been denied a pardon in the last 5 years. There is a waiver of that waiting period. And then this one is important for immigration purposes. It must be 5 years from the discharge of your sentence in order to apply for a pardon, which is kind of a big barrier, considering that a lot of times if you need to move quickly on getting a pardon, you can't wait 5 years. But we've seen that the Board of Pardons is really good with waiving this 5-year period if you have a good reason for it. And the I'm going to get deported if I don't get this pardon is a good reason. I think that would be something where we would be able to show that in front of the Board of Pardons and then be able to get through the 5-year waiver of the waiting period. This can get kind of complicated because it's not when someone's sentence ends. For example, you can see in my second bullet point there, like a person who left prison in 2017, that's not when their 5 years starts. Their 5 years would start when any lingering effect of their sentence is still there. So parole, probation, whatever that's still happening, that they'd have to wait until the end of that, and then 5 years on top. So the pardons process itself, the applications are all online. So for practitioners who are looking to help an individual, a non-citizen, with pardons related relief, it really just starts with filling out an online form and then sending it into the Board of Pardons. It is a little bit of a slow process, but I think they're getting faster now. It used to be that they'd have 2 pardons meetings every year. Now it's more like 3 or 4. So first you do the application. I recommend writing a cover letter for your individual you're seeking a pardon for. It's always important to have recommendation letters. I've seen several examples where especially the Attorney General will see someone who doesn't have recommendation letters and is up in front of the Board of Pardons by themselves and question, like, do you have any community support? Which, fair or not, it's always good to show that you have community support. The first step then after you send that in is that there's a clemency review commission. There's actually a University of Minnesota professor, Professor Moriarty, is part of the clemency review commission. They have 9 members. They would review that and give their recommendation to the Board of Pardons. So if you pass that stage, then you would go in front of that 3-member board. And again, it's the AG, it's Governor Walz, and it's Natalie Hudson, the Chief Justice of the Minnesota Supreme Court. And then they decide right then and there, after about 15-minute kind of dialogue where the person seeking a pardon is able to share their experience, share why, and usually talk a little bit about the victim, or even if there was no victim, like how it impacted the community. And then the Board of Pardons, they decide right then and there. And so people leave knowing whether or not they've gotten pardoned. Sometimes they advise people that they're not gonna give it this time, but they should come back. There's not really like, it's very much on vibes. There's no case law around this or anything like that. And it's not a court in the traditional sense. In my experience of both advocating for folks to have pardons and also reviewing pardon applications in a previous position, I've really found that the worst thing that you can do is not be transparent about your crime. And so sometimes people come to the pardons process trying to show that they're, so changed from, 1995 or whatever. And really the pardons board isn't always looking for that. I've seen them reject people for being what I would call too perfect, where the pardons board says, well, why do you even need this pardon? Like, you are now living a great life. It doesn't even seem like you need it. So there's just really, it's important for people to be themselves at the Board of Pardons meetings and in their application. This is a random kind of tidbit, but the governor is obsessed with people paying off all of the fees or court-ordered fines or whatever. So if you ever bring someone before the Board of Pardons in an immigration setting or for anything else, have them pay their fees first. I don't think I've ever seen him grant a pardon where fees were still outstanding. Like I said, especially the Attorney General really likes to think about the victims in the case. And so if there is one, it's really important to recognize not just that the person seeking the pardon has changed and is better, but also that there was a victim and they recognize that. I've seen a lot of rejections where the Attorney General will say like, hey, this is great, you've done great, but there was a person who was harmed in this instance and we haven't really heard about that person, so I can't support you. And then it's really painful to see people like relitigating their crime, basically saying like, actually, I didn't, I got the short end of the stick, I didn't get due process. Pardons are not the arena for that. So, okay, let's say that you've brought somebody before the Board of Pardons, you've been granted a pardon. And it's for one of the offenses that the INA allows for pardons to be a form of relief. Well, depending on where someone is in their immigration status, you may have to reopen their case if they have an old deportation order. You may have to file a motion to terminate if there's ongoing proceedings. Sometimes people, and I think this is sort of where I envision this going, is just helping non-citizens get a pardon preemptively. And then you really don't have to do anything if they're not already in some sort of immigration issue. Just having proof of the pardon for future use is enough to sort of stave off any kind of future immigration consequences. So the last thing I want to do is tie this a little bit back to what we have done over the last 2 years. I'm hesitant on sharing a lot of details because we're in the middle of our work with this individual, and it's important that this does not become a focus of any of the media in any way. So we had an individual, a client who has the Southeast Asian background. They are a non-citizen. Their family fled the Khmer Rouge. They were convicted, actually pled guilty of a very serious crime at 14 years old. This individual served almost 2 decades in prison, was out for 5 years, got married, had a kid, and right around the time that this individual got married, he was picked up by ICE and never got to meet his child. That's been 8 years, and he still never met his child in person. And so we first started with federal clemency efforts to help this individual. There's a sort of a similar pardons experience or process with the federal government. The Biden administration, I think they had a lot going on at the end of their term and did not provide us with any relief. We hoped that they would have, because they had the capacity to just pardon the immigration consequences of this individual's actions and not the underlying crime, which is I think what everyone wanted, but that didn't happen. And so we are now pursuing a state pardon for them. Two things that we have learned in this process is that restorative justice, especially in more serious crimes, can be a really impactful piece of petitioning for a state pardon. There are, as I mentioned, numerous different personalities among the members of the Board of Pardons. Again, going back to A.G. Ellison, he really is very focused on the victim. And so we decided that having our client engage in restorative justice would be the best way to show that our client is serious about what happened to the victim, does not take it lightly. And so we're going through that process, actually about to start, and have been kind of organizing and figuring out what the best path for restorative justice can be and how to have that dialogue. But for anyone who in the future works with non-citizens seeking immigration relief through the form of pardons, I highly recommend restorative justice as a way to show the seriousness and sort of piousness of the individual that you're helping. And then lastly, the Board of Pardons will ask the county attorney if they support a pardon for this individual. And so going directly to the county attorney before that is helpful. I mean, you probably are best to be the one being able to frame that narrative with the county attorney. We were lucky in this case in that we were able to find which assistant Ramsey County attorney actually did the prosecution of our client back in 1995. She was retired, find a address, like at home address for her, send her a letter, and she actually responded to that. And we were able to have a phone call with her in follow-up and explain what had happened. She remembered the case. She was interested in knowing what had happened. And she agreed to support our efforts in this, which was a huge win, because then we took that and we had a meeting with John Choi's office, the current Ramsey County attorney, and got John Choi on board with our efforts. So I think that will serve us well as we go on to hopefully soon bring this before the Board of Pardons. So pretty sure that is all I have. Thanks so much for listening.
Just a little bit of context too. As Nate, for one thing, one of the detainee rights clients that we had several years ago was the one that sued the Board of Pardons and actually helped had this pretty crazy moment where we're at the Minnesota Supreme Court and the Chief Justice of the Minnesota Supreme Court had to recuse herself during a hearing as we did that. But the other aspect is that I just want to highlight this. What you asked what changes. It was in the last 2 weeks, but it is in the last month. And what has changed is that some members of the Hmong community, for the first time, these are people who arrived in the United States right after the CIA secret war, right? Where the Hmong, these are people, children of parents who fought with the CIA, with General Vang, who've been refugees in the United States their entire life. For the first time, we think in this history, some of those Hmong refugees were in fact deported and removed to Laos. And so that has been a big change. That is one reason why a lot of Southeast Asian refugee community members are very much afraid. Nate and I went to do a presentation with the Lao community. Some other my student directors, we went and did a presentation at the Wilder Center to talk about what to do about immigration and how to do it. And pardons was one of the tools that we were trying to get people to think about, to apply for, because the immigration system itself has so few remedies. And so Nate has been really helpful. Thanks.
Thank you to all of the students. I know students are wrapping up their semesters. Finals are right around the corner. So I really appreciate all the work that you put into the work this semester and pulling it together in such a great way for the presentations. We do have a reception up in Auerbach with delicious food, but if people do have questions, I think students and faculty are welcome to take a few before we, yeah.
This question is more for the faculty directors. And it's extra legal. Obviously, your focus is on the work you do. Do you, and if so, how do you coordinate or interact with the people on the other side, the public side, the social and political side? Is that even a possibility?
I'll say yes, absolutely. I've worked quite a bit with community organizations, people with social organizations, and I've worked, quite a bit with legislators and politicians. One of the things that the first Trump administration did was it galvanized certain states and organizations to look at potential ways to try to protect their communities. And so even before before the election, I was involved quite a bit with some efforts to try to pass similar legislation in Minnesota. So we've done that. We also work with community groups, people who work directly. I just did a presentation with the church that has been thinking about sanctuary. So we've done that. We've tried to present. One of the things with the Southeast Asian communities is that there's a lot of those organizations and trying to find lawyers and trying to build up that. So those are all consistent interactions and questions. Because I do think ultimately, I think one of the students mentioned, the litigation is only a tool. And if we are actually going to win this quote unquote fight, it's always hard to constantly talk about it as a fight because they have $190 billion. It is the fact that we have to create better narratives, better stories, better ways of describing the real life impact. And that's not really, as much as we would love to do it, I don't think lawyers are the best spot.
I think one of the other things I'll just add to, the education in both ways. We, for a number of years, we've had social work practicum students that are embedded in our clinic. And we talk to those students about, you're helping and supporting clients that are being served through the clinic to provide holistic services. But those social work students are also training our law students on the importance of interprofessional work together and how, the legal component, as Lina said, is one part of it. But, the individual that's coming before us and needs help in having legal tools in their toolbox, there's many other things and networks that they're creating. And then I also think, our fall immigration forum last fall, we tapped on a lot of folks that are working in the labor movement and others that are doing a lot of organizing so we can understand how we all fit together in creating a movement that really does make the United States more welcoming to immigrants, even though some of those fights we're winning. It's, one step forward, two step back, but continuing to strategize together to, collaborate on our work.
I would just add to that, just like pushing back against misinformation. I know a lot of people on faculty like Nadia, Linus, and myself have done some interviews, like Nadia and Linus did some more in-depth interviews, and just, I think, correcting some of this public messaging, are people who are undocumented in the United States, are they committing a crime, right? Just by being undocumented in and of itself. So I think just pushing back on that and kind of confronting those issues. And I think that's something that, we can do from our point as expertise, but at least have that out there. And I know there's other immigration attorneys here too. So I think not being afraid to push back when you hear something that's just blatantly wrong. I think don't let the Midwestern politeness overcome the, no, actually, that's not true.
Yeah, I have a question about similarly going off that previous question. Work with Hennepin County District Court, the sheriff's deputies. Is there any things that have been done to bridge that connection or communication or?
Yeah, in the past I've worked with, there's a really great program, it's called HUP, which is the Hennepin University kind of program, which is a way that the Hennepin County government works with other factions of the university. I have, for instance, done CLEs and presentations to Hennepin County city attorneys, Hennepin County public defenders, and I've done also presentations with different judges. In fact, I had a student come with me because she come to my office a couple days ago because she is doing a presentation to to a court not too long. So there are some of those efforts. We try to work closely as much as we can with other city governments, but just knowing, of course, that limited bandwidth and it's not always easy to figure out what is possible right now. But yeah, those are definitely lines of communication. As Nate mentioned, we have a good relationship with John Choi's office, which is the prosecuting office. And so that always comes in handy.
Yeah, I just had a question. I'm class of 85. Some of us alumni were very concerned about what the Board of Regents did in terms of that proactive, you can't make a public policy comment. And so my question is just, what has been the institutional support, both from the law school, the dean on down, and the University of Minnesota for the Binger, the Human Rights Center? And what, as alumni, can we do? Because I think that, obviously from the work you're going to do, and you are doing, there's going to be pressure. And so what, as alumni, can we do, and what has been your experience so far in the institutional support?
Yeah, I mean, I think we and faculty in the law school really tried to provide information to the regents, and a center like ours that's really founded, our mission is very explicit in the work that we're doing in the advocacy, and oftentimes falls into that area of public concern. So I think we've got a lot of support from the law school, and I think right now, as Linus was mentioning, with students being targeted, it's a balance too, and how much we're putting our voice out there. And our first concern in the clinics is the welfare of the clients and the students, and so really balancing that, but also, as Mackenzie was saying, like not being afraid to speak out and to put our actions forward in representation, and being proactive in talking about the work that we're doing. I think as alumni, offering and vocalizing your support. We watch some of the meetings at the regents level, and the university is very, very big, and I think there's justifiable concerns that people have, but maybe not really understand the work that we're doing in our corner of the university. So I think learning about the work we're doing, sharing with others, with colleagues, those that have a voice on the policies for the university, I think are really appreciated. Yeah.
I was wondering if you could speak to the expansion of 287G agreements in the Twin Cities and what you're seeing by nonprofits in California, so we don't have those issues, and I haven't had my eye on the ground here.
Yeah, I was just at a meeting with some of the governor's folks, and there was a question that was asked. Has there been any additional signatories to 287G since a week ago? And the answer right now is no. So I think the number of Minnesota counties is 5. And they're pretty rural counties, Crow County. So there's also was a very helpful Attorney General Ellison came out with an opinion explicitly talking about the inability of local law enforcement to detain or arrest people on behalf of doing immigration enforcement. And that would, in that opinion, it applied even if there was a 287G agreement. And so that was a pretty helpful opinion. But right now, it does seem like we haven't heard anything new. I do think once the Congress gets budgetary asks, and then they start saying that they can compensate local law enforcement, because that's been the Achilles heel of 287Gs, is that the government doesn't compensate local law enforcement for those actions. But once they can compensate, then that would be where you could see a lot more pressure to do that.
I think another interesting, sort of counter in terms of where messaging is coming from the Attorney General's office, but also the grassroots efforts that I think we saw really come out of some of the prior administration, the organization a lot in the rural counties that saw an influx of immigrants over the past 10 years or so. There is an organization that we partner with called Fe Justicia that's in central Minnesota in Stearns County. And one of the things that they had worked on, because there was a lot of racial profiling that was happening, and they really organized themselves and advocated at the county level and got the sheriff on board. And they had, a community-wide agreement that they signed, and those the sheriff and police from that area were one of the only two that testified on the driver's license for all bill that was passed. So I think, that's another really interesting combination and supporting, and we've worked with those organizations. We've gone and provided legal services to individuals that they're providing access to housing and connections for work and other things. And then also, doing this really important advocacy in their own community. And so, it was really interesting. Stearns County hasn't signed on to that, and see if that really sticks in terms of really making those connections with law enforcement in those rural areas, and have those last throughout, this new phase of threats to immigrants. Yeah.
Yeah, there was a discussion earlier about the need to tell stories and non-lawyers doing that. For those who listen to podcasts, the New York Times Daily is a podcast a lot of you are probably familiar with, that comes out every day. And I think it was this morning or yesterday, where they featured one of the people who was sent to El Salvador because of the tattoos that he had. He was actually going to settle in court, and now he finds himself in prison. And I thought it was a powerful story of somebody who was just caught up in this and now could be in prison for the rest of his life because of the tattoos he was wearing. So that type of story told by something as powerful as the New York Times, I think is a really good start in the storytelling.
Yeah, definitely. I think there's been some really remarkable work in the podcasts that have come out in this era, and a lot of explaining, getting all this frontline coverage for a lot of really complex areas of immigration law, and having people break it down in different ways and really making it human, and telling that story is really an important part of the work. Yeah.
There have been a couple of instances in the news where people have been apprehended by probably ICE people who are masked. Oh, what's the agency that employs masks, and what circumstances do they find it necessary to do that?
I mean, we know I think many of us saw the video footage of the graduate student at Tufts being apprehended on the street. That's exactly what happened. I don't think there is a legitimate reason for any law enforcement to wear a mask. I think the only reason that law enforcement wears a mask when they're arresting someone is to terrorize. So that's my answer. If someone else has can try to drum up an issue of security protocol BS, I don't know, but that's my answer, is that there is no reason to wear a mask. It seems very much designed, especially when they're targeting students and just people on the street, that they are intending to terrorize them. That is what their purpose is. And that's why they're following students from class. It's just beyond comprehension to me about how much they are doing what they're doing and really treating this issue. It's like the more they can say, the more they treat people like they are public threats, the more they can convince people that they are public threats, regardless of the fact of what they actually represent. That's my opinion. I'm not speaking on behalf of the Binger Center or the University of Minnesota.
Great. Well, there's food waiting upstairs in Auerbach Commons. Hopefully you can join us and continue the conversation.